Mr. Beat presents Supreme Court Briefs.
New Haven, Connecticut, November 1961. Griswold. No, not that Griswold. Estelle Griswold and Dr. C. Lee Buxton open a clinic where they give advice and resources to married couples in order to help them avoid getting pregnant. They also prescribed contraceptives or birth control for married women. Well, this got them in trouble. Local authorities arrested them for breaking a law that prohibited anyone from using, quote, any drug, medicinal article, or instrument for the purpose of preventing conception. Yep, Connecticut straight up banned using birth control. With the help of P.T. Barnum, apparently, the state passed the law way back in 1879. Well, Griswold and Buxton, as well as many others, thought the law banning birth control was wrong. After they were found guilty for breaking it and fined $100 each, they appealed to the appellate division of the circuit court. Griswold and Buxton argued that banning birth control went against the 14th Amendment of the U.S. Constitution. Well, the appellate division of the circuit court disagreed and upheld their conviction, so Griswold and Buxton appealed again, this time to the Connecticut Supreme Court, who, also upheld it. So Griswold and Buxton appealed again, this time to the U.S. Supreme Court. The Supreme Court agreed to hear arguments on March 29th and 30th, 1965. The lawyer representing Griswold and Buxton was Catherine Roraback, who claimed that the birth control ban violated the right to marital privacy guaranteed by the Bill of Rights. Now, the word privacy does not appear anywhere in the Constitution. However, there was that sneaky 9th Amendment, which essentially said that there were other rights we all had not specifically listed in the Constitution. But throughout American history, nobody seemed to give a crap about the 9th Amendment. Or did they? Well, on June 7th, 1965, the court announced that they had sided with Griswold. It was 7-2, and guess what? They brought up the 9th Amendment. They also brought up that the right to privacy was inherent in the First, Third, Fourth, and Fifth Amendments, and said that the Due Process Clause of the 14th Amendment should be applied to incorporate Bill of Rights protections to the states. Therefore, the Connecticut law banning birth control was unconstitutional. Again, privacy is not explicitly listed in the Constitution. However, it's one on which several other rights, including expression, for example, depend. Also, the court concluded that privacy specifically within marriage was a personal zone that should totally be off limits to the government. Justice William Douglas wrote the opinion, quote, would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship, unquote. The two dissenting justices, Hugo Black and Potter Stewart, just thought that finding privacy in the Constitution was too loose of an interpretation. Regardless, Griswold v. Connecticut is a landmark case that basically gave Americans the right to privacy. So many cases afterward, including the more famous case Roe v. Wade, cited Griswold afterward as justification to expand or defend privacy. It's the reason why what goes on in the bedroom stays in the bedroom, and marked a big shift away from more traditional views on birth control. And remember, today privacy is constantly under threat due to technology and mass surveillance, so it's important to remember just how relevant this case still is. I'll see you for the next Supreme Court case, jury. Well, my friend Matt Baker has a company called Useful Charts, and he sells these very useful charts, and I hang them up in my classroom. They are terrific. Here's a European royal family tree. Here is a timeline of U.S. history. So if you're a history teacher, which you probably are if you're watching this, you can hang them up in your classroom. Or if you're a history dork, you could just put it up in your bedroom.
We're not putting that in here. No.
If you want to buy one of these wonderful posters, check out the description of this video for a link. These charts are just so useful. Matt from Useful Charts has just released a new video at the same time as this one about the Vice President Charles Curtis over on his channel, which is called, you guessed it, Useful Charts. Griswold v. Connecticut, that's a pretty freaking important case right there. What other Supreme Court case should I cover for this series? Let me know down below, and in case you didn't know, I have 57 other episodes of this series for show. Check out the entire playlist. No? Yes, please. Thanks for watching this show. Oh, hey, now I gotta go.